Opening statements began today in the Theodore Edgecomb trial. He is accused of killing Jason Clearman in September of 2020. Prosecutors allege Edgecomb shot and killed Clearman on the Holton Street Bridge. Edgecomb is claiming self-defense. His attorneys say surveillance video shows Clearman's car chasing Edgecomb after an argument. Was it self-defense is a question at the center of Theodore Edgecomb's case. Rebecca Clough goes in depth to explain why self-defense is a claim not just anyone can make in a murder case.
Self-defense is a legal term we sometimes hear in high-profile court cases, but it's not as simple as just saying the word to use it as a defense. There's a complex threshold that both prosecutors and the defense have to navigate.
And the defendant pulls out his 9mm handgun. And he raises it, and he shoots the victim in the face.
The jury in the Theodore Edgecomb trial will ultimately decide if he killed a Milwaukee attorney in self-defense or if his actions were criminal. Legal expert and defense attorney Patrick Cafferty says the self-defense argument is oftentimes decided in a case before it ever heads to a jury, usually before a prosecutor decides to try a case.
Oftentimes, the DA themselves will decline prosecution on the case and say, all right, yes, this person used violence, but we believe that they were within their rights to have used it.
When it comes to killing in this country, not many are considered justified. According to the FBI's most recent data, for every one justified homicide in the U.S., 49 were considered criminal. Most of those justified homicides, 60%, were between people who didn't know each other. But over the last 10 years, there has been an increase in justified homicides. It's up 45%. However, to even argue self-defense in court, experts say you have to first prove there's a legitimate claim.
People can't just willy-nilly walk in and say self-defense, self-defense. In essence, they have to get the permission of the judge to be able to argue that to the jury. The judge has the discretion as to whether to give the jury the self-defense instruction. And there has to be at least some facts that would support a self-defense claim before a judge would give that instruction.
University of Wisconsin law professor Ian Main says to claim self-defense under Wisconsin law, a defendant doesn't have to prove he or she would have died, but rather they believed at the time they would have died.
When it comes to using deadly force as a defense against someone you perceive to be attacking you, that has to be an imminent threat, and it has to be a reasonable belief that you, in fact, are subject to deadly force in order to use it.
That reasonable belief is what Cafferty says can make a self-defense trial even more difficult for a prosecutor.
Here, they have to prove all the things they ordinarily would in a intentional homicide case, but now they also have to prove what was in this gentleman's mind at the time that he pulled the trigger.
Main says a big factor juries consider is whether the defendant provoked the circumstances that ultimately led to deadly force.
One of the major kind of aspects of self-defense law is provocation. And you can't claim self-defense generally if you caused the problem.
It's just one of the big questions that ultimately the jury will have to answer in the Theodore Edgecomb trial. Reporting outside the courthouse, Rebecca Clough, TMJ4 News.